Hello, everybody. Welcome to the Outcast Podcast. This is Greg sitting in here with you. Hope everybody's having a great Monday afternoon. We were supposed to have court today, and there is still plea negotiations going on from Thursday of last week, which is day 150 on here. I'm going to show you the 3 days that I think this is where the mistrial and pleas are coming from. These are 3 serious mess ups. I can go back to when Glanville was in office with no problem, because there was a lot of mess ups there. But I want to focus on the last 3 that I think caused this, mainly because there is, to me, significance in day 138, 146, and 150. Day 138, DDA Sprinkle is doing what Love said do. DDA Love has told him to do. But at the same time, this becomes the first major mess up for the state. So let's get into day 138, and then we'll kick into day 146. I've got all the videos queued up where I want them. So here we go with the first day, day 138, here on the Outcast Podcast Live on YouTube.
Okay, and Your Honor,
when we were up here at the bench.
So, Your Honor, I'll ask additional questions that I think will.
Sustained.
After seeing this
Your Honor,
number,
I have a motion, please. May we step up?
Yeah. I'm going to excuse y'all to the jury room.
Your Honor, may we excuse the witness?
Yeah. Mr. Smirker, you can go ahead and step outside for us. Thank you.
Your Honor, so
Your
my well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up? I don't want to.
yes. Would you put it up? First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with where's the phone number? There it is.
Yeah.
Okay.
The comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor.
to
I'm
You are asking him that.
and I understand the court. I'm asking
You
him
don't.
what handle it's next to, and what he did
Yes,
after
y'all hear that?
seeing
Do
what
you?
he saw
Let's back that up real
on this.
quick.
I'm asking him, and I understand the court. I'm asking him
you?
what.
Do you? It's sad that a judge is going to ask you, do you understand what's going on?
Handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked for. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel
Honesty.
so
You're
that
talking
we
about
can
DD
deal
of love. She doesn't
appropriately
know
with the
honesty.
evidentiary issue.
She don't know what honest is.
Was any of it being offered
If she
for
did,
the
this
truth?
trial would
And
never
you
be
said
going on.
no, and then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is it?
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And
She
again,
is so.
this
Look
piece
at
of
her pen.
evidence
Look
does
at her throw the
not
pen. Y'all see that?
prove
She threw
anything
the
as
pen.
anybody would be able to say. But when he saw this on
She threw
the
the
words, Your
pen.
Honor,
Watch her right here.
and again,
Watch her.
this piece of
See her throw the
evidence does
pen?
not prove anything as anybody would be able to say. But when he
Wow.
saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The
Is
entire
phone
cross.
number one of the comments?
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally
And
asked that.
I asked at the bench, is any of this being offered for its truth?
And Your Honor, to explain DDA Sprinkle's actions that he took next. Your Honor, these records
is BS
have
right
been
here. Total BS.
collected as part of what he did in this investigation. He was
This is
asked on
the state
cross-examination,
Doing
did he
anything.
take particular.
This is the state doing anything and everything they can to put these guys in jail. They are after Jeffrey Williams. They are after Young Thug. And they're going to do whatever they have to do to get this done. And that's why today, you know, we've seen continued negotiations for pleas. I'm hoping nobody takes them, but these guys have been in jail for over 2 years. They're in Rice Street. This thing could go on another 6 months, 8 months, another year. There's no telling with the state, because once the defense puts their case on, if we make it that far, then we got the rebuttal from the state. Then we'll have at least, I know, 2 or 3 days probably deciding what evidence is going to go back to the jury room. Then we got final jury instructions. This is ridiculous.
Steps to corroborate what was given to him in certain interviews. That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be. I said that was hearsay. The state said it was not. It clearly is, because
It clearly is hearsay, 100%.
ask him that specific question. I mean, listen, none of us are obtuse.
I asked.
It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is
Incoming.
that, I don't want to malign the prosecutor standing in front of me right now. So I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
All right, that's day 138. Let's go into day 146. The next time it went down, we're going to pick up where they are asking about this picture. There's no audio this day for some reason. When they put evidence up, you couldn't hear them. Here's day 146. And it's going to pick up here in just 1 second. Questions of me. And there you go. And that's when he said right there that it's the day that Quay got out of jail, or Yak, or whatever the guy's name was. I can't remember. But anyway, goes back to this is when he got out of jail. You can't mention that on the stand. The cop knew that. And he did it anyway. And here we go. This is where we're at. Let me go forward here. This is immediate.
For mistrial.
All right. Where's that other lighter at? Because I don't have one on me at all. Hold on, let me check my pocket. Hold on, it's my pocket.
Bluetooth disconnected. Bluetooth connected.
Yes.
Here we go.
Yeah, I know.
And see, Doug Weinstein makes some really good arguments here. This right here should have been a mistrial. It should have never went past this day. This should have been it. But nope. Let's give them another chance. And 4 days later, they do it again. Miss Bristol is probably get tired of this one too.
State. All right. What is the state?
Yes, Your Honor, the state will ask that you deny defendant's motion for a mistrial. The state would like to cite the court to Swims v. State, which is 307 Georgia, 651, a 2020 case, Your Honor. In that case, which was the defendant's only enumeration of error, and I'm in Division 2 of that opinion, Your Honor, Swims contends that the trial court erred in denying his motion for mistrial after his character was improperly placed into evidence during Chelsea Owens' testimony. When the state asked Owens if Swims offered any reasoning for why he wanted to escape, Owens responded, and this is what the witness said in that case. I asked Swims, why would he do that? I said, why would you want to do that? He told me because they did not honor his fast and speedy trial. He was looking at getting off on a technicality because they didn't honor that. He didn't have that for his defense. He said he was doing time. He had a lot of time in West Virginia that he wasn't never going to get out. In that case, Swims' trial counsel immediately asked to approach the bench and moved for a mistrial. The trial court judge overruled Swims' objection and denied his motion. The state resumed its direct examination of Owens, who then testified that Swims provided another possible motivation for attempting an escape, that Swims had murdered Clemson. I asked him, did y'all kill that child? And he told me, why do you want out of here so bad? So that was how the testimony continued. I'm gonna skip down. A trial court's denial of a motion for mistrial based on the improper admission of bad character evidence is reviewed for abuse of discretion by examining factors and circumstances, including the nature of the statement. Slow down reading, please. Sorry. The other evidence in the case and the action taken by the court and counsel concerning the impropriety. And they cite Smith v. State, 302 Georgia, 699. A passing reference to a defendant's incarceration does not place his character in evidence. And they cite Lewis v. State, 287 Georgia, 210 at Penn Site 212. Furthermore, Owens' passing reference to Swims' incarceration in West Virginia for an unstated crime was an unexpected answer to the question asked by the prosecutor, who was attempting to establish that Clemson's murder was the reason Swims wanted out of jail so bad. And they see Walker v. State, 282 Georgia, 703. A non-responsive answer that impacts negatively on a defendant's character does not improperly place his character in issue. After Swims' mistrial was denied, the state did not inquire further into Swims' crimes in West Virginia beyond a single confirmation that his incarceration there also served as a motive for escape. Your Honor, given what occurred in this case, Your Honor, the state's intention when I asked the question, what was the significance of that picture, the state's intention was solely to talk about the fact that Mr. Kendrick was standing on that car being that of Rayshon Bennett. His mother had identified that car yesterday during her testimony, Your Honor. So it was an inadvertent response, which was non-responsive to the state's answer, Your Honor. And given that is what occurred, Your Honor, the state would ask that you deny their motion. Furthermore, Your Honor, other factors that you look at in order to determine whether or not a mistrial should be granted is the nature of the statement, other evidence in the case, the action taken by the action taken by the court.
The what?
The actions taken by the court. Was the reference isolated and brief? And whether the jury's exposure was repeated and extensive, and was it inadvertent? Additionally, Your Honor, within the indictment, Your Honor, we did charge Mr. Kendrick as one of the overt acts in this indictment, which is Act 58, and he's also charged in this indictment in count 63 of this indictment, Your Honor, of possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm. Your Honor, so for the purposes of having to prove that count of the indictment, we will have to enter into or enter Mr. Kendrick's certified copy of his conviction, of course, with a limiting instruction that only be used against him, Your Honor. So the fact that came out during that testimony would not be substantially more prejudicial, Your Honor, given that, one, the jury has heard this indictment,
They've heard the
as well as this.
They've heard the freaking indictment. That's not the point. A police officer, a person of the DA's office, somebody in professional capacity should know better than get on the stand and say, this is the day so-and-so got out of jail or so-and-so was in jail. You can't say that on the stand. You will prejudice and influence the jury. Why would you do something like this? He knew better. And, Judge Page had a good point. The next day when they were doing the reconsideration hearing, motion for reconsideration, and they were saying how they didn't want to lose all his evidence and everything. And the judge is like, I think he did this because they were questioning his expertise. Even the judge said this on the stand.
Evidence will come out, at least that he was convicted, because we have to prove that portion of the indictment, Your Honor. So we would ask that the court deny his motion.
All right.
And we have instructed our witness, pass that as well.
Your witness ain't going to be a witness in a few minutes.
Ms. Weinstein.
Thank you, Your Honor. In the Swims case cited by the state, correct me if I'm wrong, but I do not believe that was a seasoned officer that testified about the bad character. Is that correct?
I don't know if it was seasoned.
Yeah, no, I looked. It's not.
It's
It was
an
a fellow
inmate, right? And I think there's a distinction between a fellow inmate and an officer with decades of experience. And it's not just I that think that. I mean, I think if you go back and look at Posey v. State, which you may have already looked at, 152 Georgia Appeals 216, there you have a case where a seasoned officer testified about bad character of a defendant. The court in that case called for, there should have been a mistrial. It says that when it's impossible for the trial court by corrective instruction to rectify the harm done by improper testimony, a mistrial must be granted. And again, the issue here is you have a seasoned officer, someone with years of experience testifying. And in Posey, there's really very instructive language from our courts where they say, we reiterate here, I'm sorry, I'm talking too fast.
And too loudly.
Yeah, you know what? I'm going to tone it down. We reiterate here what we say.
Tone it down, Doug. Tone it down.
It may well be argued that peace officers are not always well acquainted with our rules of evidence and that statements such as the one here are merely inadvertent. I'm going to stop the quote for a second to say something, which is, again, here we have a peace officer, here we have an investigator who is well seasoned. The quote continues, but if we refuse to reverse this judgment, then we provide no incentive to district attorneys and solicitors to counsel their witnesses, especially law enforcement officers, to avoid extraneous and inadmissible outbursts. It is high time that this court go on record as opposing without reservation such conduct by law enforcement officers. Posey is exactly on point. Posey calls for a mistrial. This officer should have known better. The state should have properly prepared the witness to not issue, to not blurt out, to not state so clearly that my client was just getting out of prison. It cannot be corrected, Your Honor.
All right. Any last words by the state? Well, actually, never mind. It's the defense's motion, so y'all don't get any last words. All right. I think I am finding that this was not intentionally elicited on the
Here it
part of the
comes.
state. However, I also am finding that this witness as a law enforcement officer should have known better than to make any mention of it. It is, however, significant that one of the charges against Mr. Kendrick in this indictment is that he is a convicted felon. Were it not for that, I would grant the mistrial motion. But given that this jury already knows that he's been convicted and is a convicted felon anyway, even without this testimony, I don't think that a mistrial is warranted. I am, however, going to give a curative instruction and as a sanction for this having occurred, that's the end of the testimony from this witness. There's going to be no more testimony from him. So he's done. All right. What I am proposing to say as an instruction is defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 and should not have been mentioned. Further, this witness, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's criminal history should not be considered in connection with any of these other defendants or any of the charges against them in this case.
Your Honor,
Yes, sir.
I would also then, because we didn't have the opportunity to cross-examine, so it would be a
Okay.
confrontation, it would be reversible error. So I'm moving,
Let me ask you this. Have y'all cross-examined him the two
Yes.
times before? All right, so we're going to strike everything
Yes,
he
that's what I
said
was-
today.
and
All right.
the notes, just like you did before, all the notes, they have to go back, give them to the court if you don't mind, put them under seal, or, and that's what I remember you doing, but whatever you did with them. And if they can't follow that instruction, please alert
All
your
right.
honorable court if you
Yeah.
don't mind.
Okay, we're going to stop it there. And now we're going to go into day 150. And this is going to be what starts what we're in right now, waiting for them to start back up. They're supposed to be 9:30 in the morning, but hey, it is what it is. But this is where it all goes to flames right here.
Left behind. Hashtag 2Bs. Life size.
And is there another hashtag?
Free Quay.
Is there another hashtag on the screen?
Oh, no.
Your Honor,
It's in this paper
Your
right here.
Honor.
You got me reading.
Your Honor, I have to make a motion.
All right, I'm gonna excuse.
I wasn't looking at the screen. I was looking at this paper.
That's fine, don't worry about it. Can I ask you to step outside for just a minute and jury? I'll excuse y'all for just a minute. Mr. Lee, can you step outside for a minute for me,
All right.
please? Thank you.
Your Honor, we're making a motion for mistrial on behalf of Mr. Nichols. We're not going to be able to unring this bell. Your Honor, this is the exact same issue that while we were at the bench, I brought it up. It was Exhibit 37NN that the hashtag, there was a hashtag on that exhibit that said Free Quay, which would definitely indicate to the jury that Quay, has spent time in jail or in prison. The state agreed. We stipulated that they would redact it, and then the state presented, I guess, to the witness the unredacted version, didn't prep him to not comment on it, and he did. And Your Honor, before we had the opportunity for you to preside over us, this happened already again. and I made a motion for mistrial. Now it's happened again. So now the jury has repeatedly heard about Mr. Nichols being in jail, being in prison, and you could not unring that bell. We would ask for a mistrial.
Your Honor, Carter Matthews for Mr. Marquavius Huey. We join in that motion for mistrial. And what's important for this court to know is that 45 minutes ago, there had been a reference to a person being in jail. Now, this witness has identified Marquavius Huey and has also identified Marquavius Nichols. So all the state had to do was ask this honorable court for an opportunity to have this witness maybe step out of the courtroom and go over with that witness that, we don't need to say anything about someone in jail, what have you. That did not happen before he went on the stand, nor after that first slip up by this witness. There may have even been a document right there on the witness stand that should have been pulled from the state of Georgia from that witness stand so that this could have been avoided. So, Your Honor, we are joining in that motion as well.
Oh, hang on. It's all right. You just didn't know, but we'll let you know when to come back in, okay?
So we join in that motion, Your Honor.
Your Honor, and I just want to briefly add that it is painfully obvious that the state is not prepping their witnesses. You can tell by the way when the witness spoke the first time and he said, oops, am I not supposed to say that? Like, oh, I had no idea, which makes it obvious that the state had not spoke to him, had not prepped him, and this has happened repeatedly. It's happening over and over again, Your Honor, and we're just not going to be able to unring 100 bells.
And finally, Your Honor, Mr. Marquavius Huey, it's been established that that his nickname is Quay.
Okay, isn't there going to be, we talked today about, isn't there going to be a stipulation that references to Quay, at least at some points, are not either Mr. Nichols or Mr. Huey? We did.
Yes, Your Honor, and that's a few things. So one, Your Honor, it was not intentional because we clearly.
Okay, but it was sloppy because I presume he's reading from the document that you handed him instead of reading from the screen.
And we should have instructed him to read from the screen, but.
Or you should have presented him with a document that had that part redacted. It's just sloppy.
The issue came while he was on the stand, Your Honor. So the issue did not come prior to. Ms. Westmoreland walked up to me while he was on the stand and said, I'm going to have an issue with that. Can you redact it? That is when the state became aware.
Then it should have occurred to you, you know what, I'm handing him a hard copy of this document that is unredacted.
But not if there's multiple Quays, Your Honor. If I don't know which Quay that.
Hang on, can we stop having people come in and out when I've asked the witness to step out and every time the door opens, they can hear what we're talking about? Please, just for a few seconds. I'm not asking anybody who's in here to leave. God. Huh?
And so that is the point in which we learned of it, is we redacted it on here. Ms. Westmoreland brought it up here.
Yeah, and you didn't read it. So the jury didn't see it, but now the jury has heard it. I don't think it is really that, much of a crisis, because there is going to be this stipulation that Quay is not always either of these defendants. So, nor is it obvious to everybody that free whomever is such a quote about who knows, everything these days. And so it doesn't necessarily indicate that whomever Quay is, Quay spent time in jail or in custody or in prison or anything. They say it about, Hollywood stars who are in a breakup. It's not so obviously, oh, this must mean this person was in prison. But also, we were already saying Quay isn't either of these people. So let's just, and whether this was one of these people or I don't even know who it did refer to.
And we don't know because it's not his post. He was reading someone else's post. So it could be a multitude
Okay.
of quays.
You talked to his attorney
Yes.
earlier, right?
Yes.
And did you get any kind of an indication? I don't know if this
It
was
wasn't
one
an
of the
issue
things you
ear-
were gonna, but it's an issue now. And you said before lunch that you were gonna ask Mr. Rubin.
Yes, we did ask.
Do you know at this point whether the free quay reference, this wasn't even his post, was it?
It wasn't, and it wasn't an issue until Mr. Westman. So when I talked to Mr. Rubin at lunchtime, this wasn't something I was going to address with him because it wasn't I did not realize it was an issue. Mr. Rubin found out for me that Slack Quay is not either of these two quays.
Okay, but this isn't Slack Quay, this is just Quay.
Right.
I know. So why doesn't everybody, well, they don't know how it's spelled, they only heard it. Why doesn't everybody just enter into some sort of a stipulation that the free Quay or the reference to Quay just now isn't either of these people?
I don't know if it was.
Whether it, okay, so,
Your Honor, the state can enter stipulation that we weren't referencing it. We as the state of Georgia.
okay, that is not a reference to, if you would prefer that.
I don't know what the poster is referencing.
I don't honestly really care what the poster was referencing. What I'm trying to do is fix your sloppiness so that everybody won't have wasted, 10, 12 months of their lives in this trial. Okay, do it now. Y'all work on that. I'm going to take 5 minutes.
And that, folks, right there is the beginning of the end of the YSL trial. We're just waiting on tomorrow morning. Tomorrow is the 29th. We're supposed to have a 9:30 start time. Some people that were in the courtroom were saying that there were some plea negotiations going on. I wouldn't doubt it. These guys have been in jail over 2 years in Rice Street. I don't think Jeffrey Williams will take one. If he does, it's going to be a misdemeanor. Only bad part about that is a lot of your British controlled countries, Canada, Australia, England, the EU, most of the EU, a misdemeanor here is a felony there that would cripple his career as far as being able to go overseas and stuff like that. But this trial should have been over a long time ago. It should not have went as long as it did. I'm mad at Glanville. I'm mad at Whitaker. And I'm mad at Fonnie Willis for bringing this. And I hope this cost her the election, trying to keep this thing going. Because there's a lot of mad people out there that's probably going to vote against her. You've been listening to the Outcast podcast right here on YouTube. Thank you for joining me, and y'all have a good night.